Hello, everyone, and thank you for joining us for today's educational seminar. This educational seminar was actually envisioned, as a hot topic session with public interest lawyers being at the forefront for social justice issues. We thought we'd wait and pick an actual hot topic close to the session. So we're really excited to have three attorneys joining us who have experience in guardianship law to talk through the controversies surrounding Britney Spears and how guardianship would work in Illinois. We're also leaving 5 to 10 minutes towards the end for questions. So if folks have questions, feel free to use the chat, but we'll also save time for you to answer, to ask those questions during the seminar. And then this is also an extra special educational seminar where we have our talkbacks after the seminar. So for anyone who wants to hang out afterwards, we'll go into breakouts and give you time to interact with each other. But on to our hot topic session. So we are thrilled to have joining us Charles Golbert, who's the Cook County Public Guardian, Cristina Headley from Equip for Equality, and Lisa Murphy from Chicago Volunteer Legal Services. So to start, each of them are going to explain their roles and their offices, and then we'll go through and talk more about Britney Spears. So Chuck, do you want to start us off talking about the Public Guardian's Office?
Sure, thanks, Brett. So we have three main practice areas. In our juvenile division, we represent about 7,000 children in abuse and neglect cases in the Cook County Juvenile Court. And in our domestic relations division, at any given time, we represent about 700 people in some of the most acrimonious and most bitterly contested custody battles pending in the domestic relations court. And then our adult guardianship division, which is what I'll be talking about this afternoon. And for all of our areas, we have about 200 people, about half of whom are lawyers. We have a very interdisciplinary staff. So in our adult guardianship division, we represent, we're appointed as the guardian for about 700 adults who have a cognitive disability and who need a guardian. And we manage about $100 million of collective estate assets, including assets in other states and even assets in other countries. And the people we serve all of Cook County. Cook County is one of the largest and most diverse counties in the country. So we serve people from all walks of life. We have people under our guardianship who are doctors, lawyers, professors, bus drivers, hairdressers, artists, you name it. The majority of the people we serve, about 80%, are older and have an age-related dementia such as Alzheimer's disease. But about 20%, and it's this 20% that restoration comes up much more often and are younger and have developmental delays or mental health diagnoses or blunt trauma injuries to the brain and so forth. We're the last resort guardian. So usually if you need a guardian, usually somebody in your family would be your guardian. Children, perhaps nieces and nephews, perhaps a sibling. So all the people we serve as guardian for either have no family at all, they've outlived their families, or the court is concerned, for example, issues of abuse, issues of financial exploitation, or maybe there's a perfectly appropriate son or daughter, but they live, say, in Japan and are really not able to be the guardian. So we're the last resort guardian. The guardianship is very interdisciplinary, so we have a very interdisciplinary staff, attorneys, case managers, home care specialists, social work background people, especially with expertise in gerontology, property management specialists, asset collection specialists, financial services specialists, public benefit specialists. And our office never closes. We're open 24 hours a day, 365 days a week, 7 days a week. We never close. So, for example, if a hospital needs an emergency medical consent on Christmas, or an issue about removal of life support happens on Saturday or on New Year's Day, we are available to deal with anything that happens to anybody we serve. And that's a 2-minute overview of our office and our work.
Thanks. Cristina, tell us a little bit more about Equip for Equality.
Hi, everyone. Thanks, Brent, and thanks for having me and putting this session together. I think it's great to get some different perspectives on this issue and talk about it. So yes, I am from Equip for Equality. I worked there for about 6 years. And Equip for Equality is the protection and advocacy organization for people with disabilities in Illinois. So we're part of a federal network, and there's one agency like us in every state. And we do, a lot of different types of advocacy work for people with disabilities. And I primarily handle cases on the rights of people in facilities, nursing homes, state mental health and developmental disability facilities, and folks who live in residential homes in the community. And I also work on adult guardianship cases. And in those cases, we represent the individual with a disability, or the ward, or, the respondent who is being, someone is petitioning to have guardianship, over. And so we help, in basically 3 different areas in representation. So we help, in the first place where an individual is objecting, to a guardianship being put in place. We also help individuals to restore their rights or terminate their guardianship, or we help in situations where a guardian needs to be removed because they're doing something improper, or to maybe object in court or advocate with the guardian to make sure the individual's wishes and rights are being respected. Our philosophy with guardianship really mirror what the Probate Act says in Illinois, that guardianship should really only be utilized as is necessary to promote the well-being of a person with a disability, to protect them from neglect and exploitation, abuse, and to encourage the development of maximum self-reliance and independence. The Probate Act also instructs that guardianship should only be ordered to the extent necessitated by the individual's actual limitations. Oftentimes, though, we see that this practice doesn't happen, and people are often too quick to petition for guardianship, and there are issues where courts do not always provide the best oversight of these cases. I think primarily we've seen, in the past, that parents of children with an intellectual disability or developmental disability are often told by their school districts that, right when their child turns 18, they need to petition for guardianship. And so, we kind of think that's, in some cases, it's not always the best result. So we do a lot of education surrounding, guardianship too, and informing people about, what some of their other options might be. And I think that, the Britney Spears case is just a really sad situation, but I think it has brought a lot of attention to guardianship issues across the country, which don't always get a lot of attention. So thanks.
And Lisa, tell us a little bit more about CPLS's role.
Yeah, so CPLS is a civil legal service provider, and we get involved in all kinds of civil legal issues, but I work mainly in our adult guardian ad litem program. So we will sometimes represent parties petitioning for guardianship, but most frequently we are appointed as what's called a guardian ad litem in so where we have minor guardianship cases, we also are in domestic relations cases, but I work in our adult guardianship program. And in those cases, the judges will appoint our organization, usually in cases where the assets are limited or it's like a pro se petitioner, the judge will appoint us. Our job as guardian ad litem by the statute, our main job is to go and meet with the person who will potentially have a guardian. Traditionally, that's a face-to-face meeting, and there's a list of rights that that person has that we're supposed to read to them. And we're supposed to interview that person with the respondent in the case and try to get their opinion on whether they want a guardian, whether the person petitioning to be their guardian is someone that they would want. As the best as they can voice that opinion, we're supposed to try to elicit that from them and then report to the court. Our job usually also involves some kind of an investigation into who's petitioning for guardianship. Is that the right person for the role? Occasionally, we get called in after a person has already been what we call adjudicated disabled. They already have a guardian, and maybe Adult Protective Services has become involved because there's a report of physical abuse or neglect or financial exploitation. Sometimes then the judge will either reappoint a guardian ad litem or appoint a guardian ad litem, again, to investigate those allegations. Or if there's anything that comes up where a judge feels like, I need more information here, the judge isn't able to get off the bench and talk to everybody and do his or her own investigation. So usually they'll appoint a guardian ad litem to go out and talk to everybody and try to gather information and do some more of the investigation role. So we have kind of, usually we can tell the broad scope of what our job is, but our main charge is to look out for the best interest of the ward or the respondent in a case, and really kind of report back to the judge as far as what we feel would be in that person's best interest, whether they're receiving the right services. Does the proposed guardian have a realistic care plan? And kind of along the lines of what Cristina was saying, sometimes sometimes families will rush to guardianship court, or they'll have a medical provider or somebody tell them, you need guardianship to make this type of decision. They'll end up in guardianship court and with our office, a guardian ad litem, and after looking at the paperwork, maybe they don't have the necessary paperwork to meet the procedural steps, and maybe we'll talk with them, and guardianship really isn't the best solution for what they're looking for. But I do think that the Britney Spears case has brought attention to kind of some of the things that are missing in our statute, some of the work that we need to do on focusing maybe on less restrictive measures rather than guardianship, to help support individuals in kind of making their own decisions and that kind of thing. So that's a broad overview of what we do, but we can talk more specifics about Britney's case.
Thank you. And so before we kind of go into different topics that have come up with her case, do you three want to share your thoughts generally on the Britney Spears case?
Yeah, I have, thank you, Brett. I have a few thoughts, from 1,000 feet up, macro type thoughts. So in some ways, the case frustrates me very much as a lawyer involved in guardianship for two main reasons. One, it seems as though whenever there's a Hollywood trial, it doesn't matter if it's a criminal case, if it's a Hollywood divorce case, here it's a Hollywood guardianship case, it's like completely different rules of evidence and procedure and decorum, and everything seems to apply in Hollywood. That was a frustration of mine when I was watching the O.J. Simpson case every night. It's like, what? They allow that in evidence in Hollywood? That's crazy. It's so 49 states plus the District of Columbia inherited English common law, while Louisiana inherited the Napoleonic codes. Everything's different in Louisiana. For whatever reason, everything seems to be bizarre and different in Hollywood. Kind of a second frustration is that there are commentators on the Twitter and on TV and about this case, but most everything is closed. Most of the file isn't public. So people are prognosticating and commentating and tweeting and twittering and all that when they don't necessarily know anything about the case. By the way, that's in contrast to most guardianship cases here in Illinois and other parts of the country that for the most part, unless the respondent specifically asks that it be closed, is completely open other than the initial medical reports. That being said, though, I agree with Cristina and Lisa that it's good and that it's important that this case has called attention to guardianship and gotten people talking about guardianship. I say that because guardianship is something I think very few people know much about or even have an awareness of. And people should know about it and have an awareness of it because it's a very big intrusion on an individual's civil rights and liberties and autonomy, and it should be focused, as narrowly as possible, only used when necessary, but that's not always the case. Guardianship is also a rapidly growing phenomenon, and that's because of the aging the demographics of our aging population. As the baby boomers are reaching the age where they're getting dementia. So it's a growing phenomena that's a big intrusion on civil rights that a lot of people don't know about. That's not a good thing. And to the extent that this case has called attention to some of these issues, that's a good thing. The other thing I would say is that there's very little data on guardianship. So across the country, there are different models for guardianship and different models for what I do for public guardianship. Some jurisdictions, public guardianship is government offices like mine. In other jurisdictions, public guardianship is not-for-profit corporation, not-for-profit like charitable organizations. In some jurisdictions, for-profit corporations are basically the last resort guardian, which I think is a huge problem. Infusing a profit motive into guardianship for really vulnerable people who don't have anybody else, to me, is very scary. And I think one of the problems that might be driving some of the problems in the Britney Spears case is that there's this unusually huge profit motive going on. And I wonder how much that is driving problems. I've actually spoken and written about the need to get profit motives out of guardianship. And shockingly, there's hardly any research on what models of guardianship work best. Is it public guardianship? Is it not-for-profit? Is it private? Some guardianship offices like mine are more legal focused, some are more social worky focused. And we don't have any data on what works best. And so to the extent that all these issues are coming to light and they're getting attention and hopefully maybe will spark research, that can only be a good thing.
Thank you. So let's move on actually to our different topics. Lisa, do you want to start us off with choice of attorney?
Sure. So this issue has come up quite a bit, kind of as Chuck mentioned. There's a lot of commentary out there about the Britney Spears case and whether she was able to choose her own attorney. I'm going to talk a little bit about in Illinois how it works, how whether they're able to choose an attorney or not, and then we can talk more specifically about Britney's case. So I think what's key here is kind of at what point you are in the guardianship process. Before somebody is adjudicated disabled, so we call it pre-adjudication. This is the point where somebody is asking the court for guardianship. They're asking that the court declare a person incompetent so that the petitioner can make decisions for that person, who we call the respondent. And that's usually the point where, like I said, the court appoints a guardian ad litem if the respondent will not be in court. And for a lot of this, I'm going to speak specifically to the way it works in Cook County. Other counties their process might be slightly different, but it's generally the same. If the respondent is going to be in court and the judge can interview them personally and get their opinions, then sometimes the judge will waive the guardian ad litem appointment. If they cannot be in court, usually the judge will appoint a guardian ad litem to go and meet with them. And if the respondent is objecting to guardianship, Illinois statute requires that they be provided counsel. Usually in our courts, that means that the court appoints counsel for the respondent. And this is where there's usually, at least in Cook County, the probate court is a small world. There's usually a list that the judges work off of attorneys that frequently act in that role. occasionally we get appointed to represent a respondent. If the case comes back for after a post adjudication, sometimes our office will get appointed. But usually a judge is going to appoint counsel for that person. So in that case, the respondent would not have a choice of an attorney. However, I have had cases where the respondent is allowed to hire their attorney if they have not been, so this is before they've been adjudicated. No court has said that they can't make decisions. So I've seen respondents hire private counsel, and the judge will allow that counsel to file an appearance and act in the case. Now, after a person has been adjudicated disabled or incompetent, then we are dealing with the question of their ability to contract and hire their own counsel. I feel like the judges in our courtrooms are willing to entertain, a counsel that a ward has hired. But I think in a lot of cases, if a case is coming back where you have a ward that's asking to be restored, which we'll talk about in a minute, or they're asking to hire their own counsel, I think the judges would consider it, the judges that I work with, or they would they would also appoint a guardian ad litem to further investigate best interests. Now what's come up in Britney's case is, so it's, from what I've read, immediately she was appointed a court appointed counsel, but that was not somebody that she chose. And she's now since raised concerns that she wants to hire her own counsel. Another issue that came up in her case that we see a lot too is that her family petitioned for an emergency guardianship, or I think they called it like a 5150, where they were concerned of her well-being. So when you petition for an emergency or a temporary guardianship, that's when a lot of notice requirements are, there's not a notice requirement because it's considered an emergency. Sometimes it's harder to get a guardian ad litem out to see the person because you might be dealing with an emergency situation where the family is asking that they be able to step in right away because there's the harm that the respondent might suffer. And from what I've read, so California has a 5-day notice requirement for a temporary guardianship, but the judge can waive that if they feel like there's going to be immediate or substantial harm. So in Britney's case, that was waived. The judge appointed her counsel, but appointed a temporary guardian. So it's the temporary guardianship is where I feel like sometimes we can run into trouble because the notice isn't honored. There's not the same process of having somebody go out and meet with the respondent, getting their opportunity to object and appear in court. Usually those temporary guardianship proceedings are quick. And sometimes that's needed. Sometimes it's an emergency where there's a major life and death decision that needs to be made quickly, and we have a person who's not able to communicate or voice that decision, and a family's looking to come in and make that decision for them. So the choice of the choice of attorney can be, it's critical at what stage you're in the guardianship. Maybe Chuck and Christina have more insight into a respondent choosing an attorney or a ward choosing an attorney, but I think you get into questions of, after someone's been adjudicated disabled by a court, that's when you get into questions of whether the person's competent or not. And I think I also read something that there was somebody that had asked the judge to appoint a guardian ad litem for Britney Spears to see if she was competent to hire an attorney. And I think the ACLU filed some pleadings voicing an opinion in the case that, why can't the judge just interview her and see if she's competent and make that assessment kind of on the spot. So there's some room for probably improvement in the process and to speed things up, or give the person some more autonomy in the process.
Thanks, Lisa. Chuck, do you have any thoughts on that, or do you want to? You can also then talk about the choice of guardian.
No, I think, Christina, do you have any? I don't have anything to add to what Lisa said. Okay. So the choice of guardian. So first we have the prerequisite to that is, well, who can serve as a guardian? And in Illinois and in most of the states I'm aware of, it's pretty broad. In Illinois, you have to be 18 years of age or older. You have to be a U.S. resident. You do not have to be an Illinois resident, just a United States resident. Now, if you live far away, even in the United States, that might make it logistically more difficult to be somebody's guardian, but that's the only requirement, US resident. You have to be of sound mind, whatever that means. You have to be yourself not adjudicated, somebody with a disability who has a guardian. Felonies. So the Probate Act says that you cannot be a guardian if you've been convicted of a felony, unless the court decides that notwithstanding the felony, it's still in the best interest of the person about to be appointed a guardian, have this person appointed as a guardian notwithstanding the felony, except certain felonies are absolute bars. And those are felonies that involve harm or threat of harm to a minor or to an elderly or disabled person, including felony sex offenses. So that's who can serve as guardian is pretty broad, but that doesn't say who's the best person to choose for the court to appoint as guardian if the court has more than one choice. So a couple of rules. Public guardians like my office are only for the last resort. Case law says that there's a preference for family members. Case law says that we presume that family members are going to be more solicitous of the individual's welfare than a public guardian or a corporate guardian. My office is appointed in cases where families tend to disprove that presumption. For example, where there are concerns of abuse or financial exploitation. All right, what if the individual about to be appointed guardian expresses a preference for who they want to be their guardian? So in Illinois, the courts must give that, quote, due consideration, whatever that means, due consideration. But the court has discretion to appoint somebody other than who the individual prefers. And I've seen that happen in cases where the individual is saying, I want my daughter Sarah, I want my son Johnny appointed, but that individual has been shown to have plundered their bank accounts and their assets. So the court will give due consideration, whatever that means, and then appoint a different child, or if there's not another family member of my office. Illinois also allows you to designate in writing who you want to be your guardian before you ever need a guardian. You designate it in writing when you're of sound mind, kind of arcane language, but that's what the Probate Act says before you are appointed a guardian. But that's very rarely done. And in fact, I've been doing this for 30 years, and I cannot recall a single case where that's ever been done. And actually, I was going to ask Cristina and Lisa if you've ever seen an 11A6 designation of a guardian in writing.
I've seen it listed in executed power of attorney, and I have used that in court to to advocate for an individual's preferences on their guardian, on their choice of guardian.
Interesting. So it's very rarely done, but there is this provision to designate in writing before you ever need a guardian who it is you will want to be the guardian if you ever need one. One of the reasons that's rarely done is because if you do think about estate planning and see an estate planning attorney, they're probably going to push you toward powers of attorney and or trusts so that you avoid guardianship altogether. So it's rarely used, but there is that provision. And that's what the Probate Act here in Illinois has to say about choice of guardian.
And then what about restoration and modification of guardianship?
So restoration, I like to call restoration the ultimate happy ending of a guardianship case. That's where the court decides you no longer need a guardian, you have all your autonomy restored to you, and the probate case goes away. The ultimate happy ending. So in the Probate Act, it starts with the request for restoration, which is very broad in the Illinois Probate Act. It says a request for restoration can be made by the individual or anybody any person on the individual's behalf, and it can be communicated to the court or to the individual judge by any means, including but not limited to an informal letter, an informal telephone call, or an informal visit. So this request for restoration, what constitutes request is pretty broad. And here in Cook County, the judges, if they sometimes they get a letter from the individual saying, I don't want to guardian, the judges treat that as a request for restoration. Sometimes the person says, I don't like my guardian, I don't want it in court, and the judges treat that as a request for restoration, as they should under the Probate Act. Once there's that request, a doctor's report is not a requirement under the Probate Act. But I'll tell you, as a practical matter, even though it's not required by the law, it's something, in my experience, judges are looking for. Now, why is that? It's because the initial guardianship petition must include a doctor's report accompanying it. And so the adjudication of the need for a guardian is based in part on this doctor's report. And so at least here in Cook County, my experience is that judges are going to be very hesitant to restore somebody without a doctor's report, even though it's not required by the law. The court often appoints a guardian ad litem. I say in the overwhelming cases, the court appoints a guardian ad litem to talk to the individual, talk to medical providers, talk to the doctors, and serve as the eyes and the ears of the court and report back to the court about restoration. The individual has a right to a lawyer, they have a right to a jury trial, and so forth. Now, in cases where the guardian and the individual agree that there should be restoration, the burden shifts. What restoration will be granted unless somebody else comes in and bears the burden of demonstrating that there should not be restoration by clear and convincing evidence. And the guardian and the individual under guardianship agreeing happens more often than you might think. That happens in the majority of the restorations that my office sees. And I'm going to talk about an ABA study in restoration in a minute. But if the guardian and the individual agrees, the burden, and there's a doctor's report, the burden shifts to anybody who's opposed to restoration. So when does restoration happen? I mentioned before that about 80% of my office's cases involve older people and an age-related dementia like Alzheimer's. The age-related dementias are progressive in nature. That means that they do not get better. In fact, that means they do not stay the same. They get worse over time. So at least my office, we really do not see restorations in those 80% of the cases. The cases where we do see restorations are cases where there's, for example, a mental health diagnosis. And I'll give a couple of examples of recent restoration I was involved in. It was a mental health diagnosis, and doctors had tried different medications and nothing really worked effectively. And then a new drug came out. A miracle of modern medicine, a new drug for this diagnosis came out, and the person started taking it, and it worked. And in cases like that, we usually do not do restoration overnight. More likely it'll be gradual, maybe 6 months, 8 months, 9 months, something like that. And they'll start paying minor bills on their own, then they'll start paying the major bills like the mortgage on their own, then they'll start balancing their checkbook on their own. And in this particular case, it was maybe 8 months from when they started taking that new drug, they were restored. Again, the ultimate happy ending of a guardianship case. Another example is some people, a lot of mental health diagnoses are treatable with meds, but people don't always want to take the meds for various reasons. And when they're taking the meds, they're doing fine. When they're off the meds, they need some help. So somebody might be off the meds for a while, they have a guardian, they start taking the meds again, and will be restored. Query though, if there's a long history of going on and off, and they're only the on is only for a short period of time, what are concerns about restoration there? I'll save, something to think about. Okay, so that's restoration. There can also be removal of a guardian. The grounds in Illinois are that the initial guardianship was procured through false pretenses, or that the guardian, him or herself, has now been adjudicated as needing a guardian, or conviction of a felony, waste or mismanagement of the estate, inadequate bonding, failure to file an inventory, incapacity, or unsuitability, whatever that means. And then there's a catch-all, other good cause are the grounds for removal of a guardian. And actually, my office is appointed in many cases where the court removes the prior guardian. It's often due to failure to file an inventory. Oftentimes, if somebody the guardian has to file an inventory every year. The probate court has checks as a tickler system to catch that if it doesn't happen. Sometimes it's just they didn't file it or they forgot, but sometimes the guardian doesn't file an inventory or an accounting because there's been issues of mismanagement, and that's how it gets caught. And my office will be appointed successor upon removal. So that's removal of the prior guardian is how we get appointed in some cases involving guardian abuse or guardian exploitation. So that's restoration and removal.
Since this is basically one of the main topics with Britney, Cristina or Lisa, do you have any other thoughts in the restoration of guardianship or removal?
I just think that, based on what I've heard with Britney, and her testimony and recently in open court, I think that this was a major, violation of professional duties of her attorney who was appointed. It seems like this was, a goal of hers for a while, and a request of hers for a while, not only for restoration, but of making allegations against her father and, the other management company who, was appointed. And, in Illinois, under our professional, rules of conduct, that attorney had a duty to bring those matters before the court, upon her request. And so, that's one thing that I find very, very concerning about her request. In addition, it just, seems like there has been regardless of her allegations of abuse, it seems like there's been, just a major breakdown in her relationship with her family, and, in particular with her father, who was her guardian of the person and is still her guardian of the estate. And like we've all said, a guardianship is a major deprivation of individuals' rights and liberties, and, someone else is making their decisions, for you. And, I think as a practical matter too, if there's a major breakdown in that relationship, that person obviously doesn't trust that person anymore, that is not a good person to continue to be, involved in their life and making these personal, decisions for them. And I think that's something that, that the court should have recognized earlier.
Thanks.
Yeah, I would agree with that, especially the point about a guardian knowing that somebody wants to be restored. In my view, that guardian has a responsibility to bring that to the attention of the court, whether the guardian agrees with it or not. And the National Guardianship Association has standards of practice for guardians. They're not law here in Illinois. They're voluntarily standards of practice that if you want to be a member of this National Guardianship Organization, guardians agree to adhere by. And one of them is that a guardian share with the court the request of an individual under guardianship restoration, irrespective of whether they agree with that restoration. I meant to mention an ABA study on restoration. I mentioned before that guardianship is shockingly not, there's very little research on guardianship and what works and what models work and what doesn't work. Shocking. One good study that we do have that's recent happens to be about restoration. It's by the American Bar Association, has a commission on law and aging. By the way, they do terrific work, research advocacy, proposing legislation. And they did it in partnership with the Virginia Tech Center for Gerontology. It's a 2015 study. Big caveat, it's only a study of successful restorations. So it does not study requests for restoration where the restoration was denied. So requests for restoration that are ultimately denied are not reflected in this report. But with that big caveat, I wanted to share just a few of the findings. One was dementia was the primary cognitive diagnosis in only 4% of the cases. 96% of the cases is something other than dementia. That's something I mentioned, what we see with my office and what I see here, mostly because of the progressive nature of age-related dementias. Another finding was that the petitioner for restoration of rights was the guardian, him or herself, in 40% of cases, and was the individual under guardianship in about 40% of the cases. That's consistent with what I see and with my office's experience. My office probably petitions for restoration, and I'd say more than half, probably a bit more than half, maybe 60% of the cases were that result in restoration. The majority of the cases, about 94% restoration was not contested. Again, this is cases where restoration happened, not where restoration was asked for but was denied. But in such cases, 94% is not contested. That's consistent with my office's experience. And in about 90% of cases nationally, it was the first request for restoration. And on average, the individual had been under guardianship for a little under 5 years before restoration happened, again, in cases with a successful restoration. So that's a little national data in one of the few areas where we actually have any data at all on guardianship.
Lisa, let's move on. Do you want to tell us a little bit more about evidence of abuse and neglect and then financial exploitation with guardianship?
Yeah, so and again, I'll be talking specifically about Illinois. So in Illinois, a few years ago, there was an act passed called the Illinois Adult Protective Services Act. And that essentially created Adult Protective Services, the agency in Illinois, and it's their job. They were tasked with setting up a framework to investigate reports of physical abuse, neglect, and financial exploitation. So this act protects adults between the ages of 18 to 59 and they define it as a physical or mental disability, including but not limited to a developmental disability, intellectual disability, mental illness, or dementia. And so Adult Protective Services, or APS, is essentially, if you're familiar with DCFS, they work in a similar fashion where they have a hotline number you can call if somebody thinks that somebody's being abused or neglected or financially exploited. There's a hotline number you call. The agency that is local to that individual will take the call, and it's their job to investigate. Depending on the type of report, they are required to actually go and make a face-to-face visit with the alleged victim within a certain time frame. There are also groups that are designated as mandated reporters, like medical providers. I believe financial institutions are listed as a mandated reporter if they think that there's some kind of abuse happening. Like if somebody brings, mom to the bank and is acting kind of suspiciously and is draining mom's bank account, and it looks like mom might have some capacity issues, then the bank is supposed to call. And how effective the reporting is in actually addressing the situation obviously depends on the situation, the agency, the caseworker that's assigned to the case. So in my experience, if APS becomes aware that there's a guardianship that exists for the person that's the alleged victim of abuse, they will write a letter to the judge and say, hey, we got this report, we're opening an investigation, we know that this person has a guardian, or if the guardian is involved in a report, they will also write a letter to the judge. That's frequently how we get appointed after someone's been adjudicated, is the judge will get this letter, they'll kind of reopen the case, appoint a guardian ad litem to keep tabs or to investigate this report of abuse, and report back to the court about what happens. Generally, APS will make a determination of whether they substantiate the abuse or they find evidence of it. They're also able to take other protective measures, like removing somebody from a home if they feel like they're in danger, or they're tasked with finding housing for that individual if they need emergency housing situation. They have pretty broad powers of stepping in if there's a dire situation. Our office, when I'm GAL and APS is involved, it varies as far as what the situations might be. Usually it's APS doing the investigation and then we are gathering the information as GAL. Sometimes we're investigating kind of side by side and working together. I think in some cases, I don't know what the exact process is, but the state's attorney might get involved and file charges against somebody if the allegations are strong enough or there's enough evidence of some severe abuse or financial exploitation. I think where it gets a little murky is when you have a situation like Britney Spears' case, where she's substantially wealthy. The parties involved in the case, in large part, are being paid by her. There is, in Illinois, it's also allowed that the ward is, they can be responsible for paying all the attorneys involved if there's a paid guardian ad litem. All of those people get paid out of the ward's assets, and that's one of the main critiques I've heard of Britney's case, is that she's kind of funding all of the people, even the people that are essentially opposed to her in the case. And when you have more sophisticated financial planners and things happening, I think you can have some financial exploitation that is harder to pinpoint, it's not as obvious as somebody going in and draining a bank account of somebody or writing checks that they shouldn't be writing on someone's behalf. You have this more professional structure of management companies and lawyers and people being paid out of her assets that can make it a little, if there is financial exploitation happening, it can be harder to find in those cases. But I find in our cases that, if a judge becomes aware that there's something happening when it involves a guardian, our judges take that pretty seriously and will look for more investigation. And then occasionally, as Chuck was mentioning, as far as removal as a guardian ad litem, we might move to remove a guardian if we feel that, or if we find that there's substantiated reports, or we find that a guardian is engaged in some kind of abuse or neglect or exploitation. We might move the court to remove that person as guardian and appoint somebody else, like a public guardian or the Office of State Guardian, to come in if we feel like a guardian isn't doing their job. Even as guardian ad litem, sometimes we will advocate for what we feel would be in the ward or the respondent's best interest. And in a lot of CPLS is usually involved in cases where there's not a ton of attorneys involved. So sometimes we'll make those motions to the court since I'm an attorney.
And then Cristina, do you want to tell us about two topics that have come up with Britney's case, the right to marry and then reproductive rights with guardianship?
Sure. So with marriage, under the Illinois Probate Act, if a person is under a plenary guardian of the person, which means a full guardianship, if they would like to get married, the guardian has to petition the court for authorization to consent to marriage on behalf of the person. And the standard that the court follows is looking for clear and convincing evidence that marriage is in the ward's best interest. In addition, if the ward is looking, to get divorced, if the person, if a petition for dissolution of marriage was filed before they were placed under guardianship, then their guardian can continue with that dissolution proceeding. Otherwise, if they want to start one while an individual is under guardianship, the guardian must also petition the court for authorization to file a petition for dissolution. And similarly, the court has to find that dissolution would be in the ward's best interests of a person under guardianship. I have had a case where long after that was filed, and the guardian obtained authorization to do that, the soon-to-be ex-spouse tried to come back into the guardianship case and tried to say that, the court was improper in doing that and allowing the guardian to move forward with dissolution. But the court rejected that and said, based on Illinois case law, this individual did not have, this soon-to-be ex-spouse did not have the standing to come back and, and contest that. I'm going to quickly talk about a few reproductive rights issues. The point, what the Probate Act is most clear about, the standard, is sterilization. And the Probate Act sets forth a very specific and detailed procedure for decision-making when considering petitions for sterilization. And this procedure was actually codified in after a 2008 Illinois appellate decision that Equip for Equality was actually involved in representing the individual under guardianship. And so under that statutory provision, a guardian has to petition the court for authorization to consent to sterilization. The court is required to appoint a guardian ad litem. The person under guardianship has a right to an attorney if they request it, or if they adopt a position that is adverse to the guardian ad litem. The court is also required to order a medical and psychological evaluation of the individual. The court must determine if the person under guardianship has the decisional capacity as to specifically the proposed sterilization. And so if the court decides that the person does have decisional capacity, then the court must enter an order consistent with their expressed decision. If they find that they don't have the decisional capacity, then they must evaluate what the individual kind of would express, if they were expressing if they were able to express kind of a clear desire. And then if they determines that they're not expressing any desire and they do not have decisional capacity, the court, reviews some factors, including examining if there are any less intrusive alternatives, and considering the best interests of the person under guardianship. And so, then just lastly, in looking at other, other reproductive rights issues like that have come up in the Britney Spears case, like Britney, I think, discussed that she would like to have another child, but was not able to have her IUD taken out. So in terms of birth control, the Illinois Probate Act, does not specifically address birth control outside of sterilization, but of the process for, determining that would follow the decision making process for a person, for a person under who has a guardian of the person. So in that case, I think what should happen is, if there's a difference between what the guardian wants and what the person who's under guardianship would want, the ward should, bring that to, or someone should bring that to the attention of the court. And, the court would have to determine, or the way that the guardian should approach this is that, they have to determine what the individual's expressed wishes are. And, the guardian must follow that unless it's determined that that would cause the individual harm. And, again, if they don't, share an expressed wish, then they have to determine what the individual's wishes would be if they were competent under the circumstances. And they should take into account an individual's personal, religious, and moral beliefs. And then, if after that inquiry, if the person's wishes remain unknown after, a reasonable effort, then a decision shall be made in the individual's best interests.
Thanks, Cristina. So with the last few minutes, I want to open up for any questions that folks have, either if you want to put it in the chat or, unmute yourselves and ask a question about the Britney case, about guardianship in Illinois, to any of our panelists. So one question that I was thinking of, Chuck, you mentioned the for-profit, that there's like for-profit institutions, and there was also a Netflix movie about this. I think it was called I Care a Lot. So just curious on your, more of your thoughts on that. When I watched that, I thought this couldn't be real, and then to find out that there is something, that it's plausible that something like that could happen.
Okay, so I actually wrote a film review of I Care a Lot for the National Academy of Elder Law's newsletter. And so, well, first off, what happened can I give away a spoiler alert? Is that okay?
Yes.
What
Spoiler warning for I Care a Lot on Netflix.
Really, I don't see happening. At the end of the film, this for-profit guardian who ends up colluding with the Russian mafia to establish a national crime syndicate to use guardianships to exploit people. So that's what happens in the film. So when I say I'm concerned about profit motive, I'm not really concerned about the Russian mafia infiltrating guardianship, but it's more the concept of these for-profit entities. And the problem is because a lot of jurisdictions never created public guardianship offices. A lot of jurisdictions never worked with not-for-profit organizations, like Catholic Charities plays a big role in some jurisdictions. And all of a sudden the baby boomers started to age, and there was a need, and they didn't have families, and the courts didn't know what to do, and these corporations stepped in to fill this hole. And there are for-profit guardianship entities here in Chicago too, and most of them are fine, but the case I would look at, Brett, actually is a different movie. There's a documentary film by Amazon called The Guardians. That's actually a documentary that's a true story. It's based on the guardianship system in Clark County, and a for-profit guardian went to jail, and it was alleged that, and a lawyer, sadly, one of the lawyers who worked for the for-profit guardian went to jail, and it was alleged that doctors who were not charged were involved in this conspiracy. And the film also paints a very not good picture of one of the probate judges. And that's more what my concern is, as opposed to what you see in, and I care a lot about the mafia getting involved in guardianship. And again, I keep going back to this, there's no research about guardianship. That's a huge problem. There's no, so maybe I'm wrong, maybe for-profits are great. I don't know, there's no research on this, but there is research on a couple of areas that arguably are analogous. Nursing home care and prisons. And study after study after study by academics, by the government, have shown that not-for-profit nursing homes have much better outcomes than for-profits. And there have been studies about which nursing homes have the worst results during the COVID-19 pandemic, which have the worst infections and deaths in the nursing homes. And again, and that's not to say that every for-profit nursing home is horrible and every not-for-profit, but at the aggregate, the worst performing nursing homes for COVID-19 were for-profits. Go figure that one out. Not for prisons. For-profit prisons performed so poorly that under the Obama administration, they stopped using for-profit prisons. The Trump administration reversed that policy. And now the Biden administration is once again phasing out for-profit prisons. We know they do not work. So why would you infuse profit motive into guardianship with people who are adjudicated to not be able to fully take care of themselves and who don't have families to do this? And Britney's case is so unique because we're talking about not just an existing estate that's been built up over a lifetime, but continuing profit, a profit maximizing entity is what Britney is. She's a brand. And so some of the issues you see, again, we don't have all the facts because the case is closed, but I suspect go back to this huge profit motive that may or may not be driving some of what's going on here.
Well, thank you, Chuck, and thank you, Cristina and Lisa. This was a really informative about guardianship, informative about the Britney case. I think it was a fun way to learn about something, although not that fun of a topic, unfortunately, with Britney. But thank you. Dozens of applause on mute for all three of you. Thank you for joining us. And then next week we'll be back for our last educational seminar. I can't believe it's already August and it's the last one. But on Tuesday, August 10th, we'll have our Incorporating Pro Bono into Your Career panel. So hope that you all will join us again next week for our last session. And then on Thursday, we'll have our reception welcoming the new class of alumni. And you all will get more emails about that. So thank you, Chuck, Cristina, and Lisa, and thank you everyone for joining us. And anyone who wants to stay on, please do to chat with other interns and fellows about today's seminar or other topics. So thank you.
Thanks, Brent. Thanks for having me.
Thank you.
Thanks.